All right, let's jump right in. Today we're going to talk about the United Kingdom's legal system, or more accurately, its legal systems. And trust me, you're going to see it's not nearly as united as the name suggests.
So, right off the bat, let's tackle the big question. When you think of the UK, you probably just picture one country with one set of laws, right? One system for everybody. But that's actually not how it works at all. Yeah, you heard that right. It's probably one of the biggest myths about the UK. It isn't one single legal entity. It's actually a union of several, and that changes everything. Get this. The UK is made up of three completely separate legal jurisdictions. You've got England and Wales, which share one system. Then you have Scotland with its own, and you guessed it, Northern Ireland has its own system too. Each one has its own courts, its own history, and often its very own laws.
Okay, so you might be wondering, how does that not just fall into chaos? Well, there's one crucial link that holds it all together. For civil cases, that's legal fights between people or companies, there's one last stop for everyone, the UK Supreme Court. Its decisions on these matters apply to all three jurisdictions, which creates this really important layer of consistency over the whole thing.
Now, to really wrap your head around how this works in practice, you need a good story. And honestly, there is no better story than the one about a woman, a bottle of ginger beer, and a snail. It's a wild Scottish case that literally changed the law for millions of people around the globe.
Let's set the scene. It's 1928. You're in a little cafe in Paisley, Scotland. A woman named May Donahue is just hanging out with her friend. It's a totally normal, everyday moment that is about to become legendary in the world of law.
So her friend treats her to an ice cream float. The owner brings over the ice cream and a bottle of Stevenson's ginger beer. Now, the bottle's made of this dark, opaque glass, so you can't see what's inside. She pours some out, takes a drink, and then her friend goes to pour the rest, and a decomposed snail slops out into the glass. I know, it's disgusting, and as you can imagine, she gets incredibly sick from it.
So here's the legal pickle. Who's responsible? Her friend was the one who actually bought the drink, not her. That means she had no contract with the cafe owner, and she couldn't sue the manufacturer for misleading her because they never spoke to her directly. Legally speaking, it looked like she had no options.
But here's where it gets interesting. She tried something totally new. She sued the manufacturer, Mr. Stevenson, arguing that he was the one who had a responsibility to make sure his product was safe. This was such a radical idea at the time that the case went all the way from this small Scottish town to what was then the highest court in the land, the House of Lords.
And you know what? The court agreed with her. They created this brand new legal idea called the duty of care. Basically, it says you have a legal duty to not do things that you could reasonably guess would hurt your neighbor. And in this case, your neighbor is anyone who might be affected by your actions, like the person who ends up drinking your ginger beer. This one Scottish case became the bedrock of modern negligence law, not just in the UK, but across the world.
So, wait a minute. A case from Scotland set a rule for everybody? How does that work if the systems are separate? Well, that brings us to the political plumbing that makes it all possible. A little thing called devolution. You see, Scotland's legal system has always been its own thing. For centuries, it's been this unique blend, a mixed system, taking ideas from the very structured, code-based civil law of Europe, but also from the more flexible, case-based common law you see in England. This unique history is so important for understanding why it's still so different today.
Fast forward to the late 1990s. This long-standing separation gets a modern upgrade through a political process called devolution. Basically, it meant creating separate parliaments for Scotland, Northern Ireland, and Wales, and giving them the power to make their own laws on certain topics.
And this carved up the powers really clearly. Devolved things, like healthcare and education, are managed by those local parliaments. But reserved things, like national defence or data protection, are handled by the main UK Parliament for everybody. That's exactly why something like the Consumer Rights Act applies everywhere, but the way a school is run can be totally different in Edinburgh than it is in Manchester.
Okay, so let's get down to brass tacks. What does all this mean for you, for me, for businesses? How do these separate systems actually change the rules of everyday life?
This is where it gets really practical. Because believe me, these aren't just dusty old legal theories. They have a massive impact on everything from signing a contract to knowing your rights if something goes wrong.
Let's talk about contracts. In England and Wales, you usually need something called consideration for a contract to be valid. That just means both sides have to promise something of value. But up in Scotland, nope, no consideration required. A contract can be legally binding the moment you agree on the main points, even if nothing has been formally exchanged yet. And how about deadlines for suing someone? In England, there's a limitation period, usually 6 years, that just blocks you from going to court. Your legal right technically still exists, you just can't enforce it. But in Scotland, it's way harsher. They have prescription, usually 5 years, and when that deadline passes, your legal right is extinguished. It's gone, poof, as if it never existed in the first place. That's a huge difference.
And here's the super simple one: the age you're legally considered an adult who can sign contracts. In Scotland, it's 16. In England and Wales, it's 18. And that's just scratching the surface. Northern Ireland, for example, has its own completely unique rules for things like buying and selling property.
So when you take a step back and look at the big picture, what do you see? You see that the UK isn't one solid legal block. It's this complex, living, breathing union of different systems, each with its own story.
The best way to think about it is like a tapestry. It's woven together from these different threads. The English common law, the Scottish mixed system, the unique legal history of Northern Ireland. And all those threads together create this really intricate and one-of-a-kind pattern.
So let's just quickly nail down the key takeaways here. First, the UK has 3 separate legal jurisdictions, not one. Second, remember the snail? That crazy Scottish case gave us the duty of care, a huge legal idea. Third, devolution is the name of the game for who makes the laws. Some powers are local, some are UK-wide. And finally, all of this leads to very real differences in the rules for things like contracts, legal deadlines, and basic rights.
And that kind of leaves us with one big question to chew on. In a world where everything seems to be getting more and more standardized, what's the real value in a country holding on to these very distinct, very old legal traditions? What do we gain from it? And maybe, what do we lose?